Are we ready for Mr. Shadowins?
Yes, Your Honor.
Come on up, Mr. Shadowins. And I know that the bonds person also had mentioned that he wanted to address the court, but anyway, for the record, this is 25T448, 25M352, 25M395, 20.
All right, pause right here. This is the classic sovereign citizen setup. I'm not a sovereign citizen, followed immediately by every sovereign citizen argument ever invented. Keep an eye on how fast this spirals, because denial is step one in the SovCit playbook.
All people v. Joseph
Have you spotted the
Shadowins,
red
who
flags
appears in
already?
person in the courtroom. Mr. McKissick from the district attorney's office appears in person as well. You're standing. So Mr. McKissick?
Yes, so I was able to speak with the defendant a little bit about kind of the 5 cases coming up. It doesn't appear that we'd be able to reach a resolution considering some of the things that I would have pointed to as direction for the defendant doesn't seem like something that they would be willing or able to do. This would include picking up one of their issues that they haven't been given any discovery on any of these cases. I let the defendant know that I myself do not give or take in discovery. That's something that can be asked for from the district attorney's office by going there physically and then asking for the discovery, which would be handed over at that time. The defendant let me know that that would not be possible for them, that he was told that if he were to go to the district attorney's office that he would be arrested. It's not typically something that the district attorney's office would impose a arrest for someone coming to pick up discovery without some other maybe factors that haven't been mentioned. So I'm kind of at an impasse as to what to do. It seems like many of the asks by the defendant is not something that I can readily take care of, even though that would be a simple solution, is just going down to the DA's office and getting up discovery. But moreover, he's asked me to take some of his own evidence, which is not something that I was willing to take at this time. I think from a procedural posture in this case, we're once again at an impasse. I think the defendant claims that they're not a sovereign citizen, even though many of their arguments align fully in place with many arguments that I've seen from sovereign citizens. He's asking for a change of venue.
This right here is a major legal reality check. There is no such thing as a common law court you can just demand into existence. Courts are created by statute and constitution, not vibes, YouTube videos, or handwritten filings. This is where most sovereign cases start collapsing.
So I am not, on and for the record, a sovereign citizen, nor have I ever been a sovereign citizen, though I agree with the state's position that many of the claims and statements I make are in alignment with that. I have clearly corrected my status as de jure on and for Teller County records that this court has admitted they haven't read. I have filed motions to dismiss many of these cases based on those records, and the subsequent motion to dismiss, Your Honor admits on record she has not read and denied. So I am not aware of any victim. The evidence I was trying to give the state this morning with respect to an alleged victim are rebuttals to affiance. So I do not qualify for an attorney. I cannot afford an attorney due to damages from the state, nor can the state provide a common law a defense with the assumption that I am a domestic terrorist. That is a clear conflict of interest. Your Honor herself has admitted multiple times on record in multiple cases, calling me a sovereign citizen, refusing to answer my questions, dismissing them as sovereignty arguments, and so on and so forth. This is clearly due process issues, clearly conflict of interest issues, and I cannot plea or proceed without full discovery of facts evidence and elements. There are also issues on the docket today that Miss Hudgens' name is under. I have never consented to an attorney. I have no discovery. I have no complaints. I have not even basic discovery. So how can I defend myself if I can't speedily rebut claims?
Okay, so thank you, Mr. Shadowins. So what I'm hearing is there's an issue about discovery. You know the process to get the discovery, which is to go to their office in Colorado Springs. They have a discovery, apparently some kind of office, and you can
Notice how he says he's not a sovereign citizen, but immediately claims special status, rejects jurisdiction, and denies victims exist. That contradiction is important because
We
courts
will
don't
arrest
care
you.
what label
Where are
you
they,
use.
sir?
They care about
I
what
wasn't prepared
arguments
to
you're
make that
actually
argument.
making.
I tried to give it to I
And
tried to
these
give
are
evidence of
textbook.
rebutting of affidavits today. Prosecution won't take it. Non-response from the DA's office, times 2 prosecutors.
stop, let's
You-
stop.
allow
I'm
me to
trying
speak, please.
I'm trying
Please
to
do not
get,
rush justice.
can we get
I'm
an
trying to answer your
answer?
question.
Well, I hear that you're saying that you don't have anything
I don't have it
from,
with me today,
okay.
but I have emails to multiple prosecutors plus Ms. Schaaf, senior investigator, requesting discovery disclosure of evidence. I was told I could go to the police station to pick it up, denying the fact that I have restraining orders from multiple police officers for whistleblowing. Okay, I can't go to pick it up in person because cops took my truck. That was the principal issue leading to all of these cases, a driving versus traveling issue deemed sovereign citizen arguments. I have never been a sovereign citizen. I have common law standing on file with the county, and I cannot get a common law court. So at this point, I don't know how to proceed without evidence. I can't plead without evidence other than non-assumpsit by way of confession and avoidance and invoke my right to subrogation.
So we have an extra special appearance, changing his status, no victim, common law standing in a common law court, not consenting, driving versus traveling, and one I haven't heard of in forever, subrogation. You want to tell us you're a sovereign citizen without telling us you're a sovereign citizen? Oh wait, you just did.
But you know, the problem, Mr. Shadowins, is you say that you are not a sovereign citizen, but as I would agree with Mr. McKissick, your arguments are in alignment with arguments that sovereign citizens make.
Which is a
So
conflict of interest.
what I would like to say, I'm not making the argument, it's you
You
are.
called me a sovereign citizen yourself, Judge.
So I would say at this point, Mr. Shadowins, that your arguments do align with sovereign citizen arguments.
Object, personal opinion bias.
I get you. So it looks like you have someone here who perhaps could take you to the district attorney's office in Colorado Springs, although I know because of your past failures to appear, he's had to post bonds, and I think he had some questions about that. But-
Yes, do I have clearance to not be arrested if I go and try to petition for discovery? I do not wish to motion for discovery with jurisdiction issues raised by the state not affording me the opportunity to rebut. The state twice raised the issue of jurisdiction, and I was not afforded a rebuttal. These affidavits clearly rebutted, and there's no notary present in the court today. Mr. Kissick will not allow me to submit evidence in my defense.
So, you know, the thing also, Mr. Shadowins, is it's very confusing to follow your arguments.
That's because I'm common law and you don't recognize that, which is the bias and conflict of interest.
That is absurd. That is an absurd argument.
Let's break this down for a second. Driving versus traveling, special appearance, non-consent, subrogation, these arguments have been rejected thousands of times
Writing
nationwide.
is not easy.
Judges
for me.
don't
I had
dismiss
to
them because they're
I mean,
rude
you
or
filed, the
biased.
last
They
thing that
dismiss
you
them
filed,
because
your
they are legally
motion to
meaningless.
dismiss was filed on the day of your last court appearance, and I did not have the time to look at that beforehand.
Motion to reconsider?
Okay. That makes no sense. Haven't ruled. You only asked to reconsider if I've already ruled.
You
I haven't-
dismissed my
Here's,
motion.
I have not,
You
I
dismissed my
told you.
motion to dismiss based saying that you hadn't read it. I take no adversarial position.
That's because you're a defendant. So the only adversarial position that you'll be taking today is against yourself with a bunch of sniffable glue sticks in your pocket. Now this judge is a very kind judge, but this dipshit is about to push her to her limits, and she's gonna do the unthinkable by raising her voice at him.
Mr. Shadowens, the reason that I told you I hadn't read it is because it would take me some time to go through it.
Understood.
So I'm not I did not rule on your motion at the last
Denied
hearing.
it.
In regard to due process of law, I went through your motion for dismissal, Mr. Shadowens, and in regard to due process of law, there's really no clarity about what specifically you're concerned about, but you have, as far as due process rights to be heard and to, let's see, to understand, well, to be heard and to have really, it says no one shall be condemned without an opportunity to be heard. So you have had the opportunity to be heard. You've appeared in court. There is no violation of due process of law. In regard to the Sixth Amendment, also I will find, as far as due process of law, if your concern is about
This is actually a huge moment. The judge is clearly, patiently explaining due process, and here's the key takeaway. Due process means you get a chance to be heard, not that the court has to
guide
agree with you.
for law-abiding
A lot of people
behavior
confuse
and
those two
capable of
things, and it
even-handed
gets them into
enforcement.
serious
All
trouble.
the statutes in these cases that have been charged as violations against you, court does find that they are sufficiently clear to persons of ordinary intelligence, and they are capable of even-handed enforcement.
I don't even
In
know what that
regard,
means, Your Honor.
wait,
I'm not
I'm responding to you raise these issues. You write due process of law with no real explanation. I have to make assumptions about what that means.
Objection, the court would not hear it.
In Sixth Amendment,
Dismissing it as sovereignty arguments, end
I
quote.
have not dismissed, I am ruling right now,
You
Mr.
can't rule, you haven't heard the matter.
Mr. Shadowens, I did read your motion and I am ruling right now, so be quiet. In regard to the Sixth Amendment, that the Sixth Amendment provides for speedy public trial by an impartial jury, you be informed of the nature and cause of your accusations, that you are confronted by witnesses against you, have a right to subpoena witnesses and right to counsel. You have all of those rights. None have been denied to you. In regard to obstruction of justice, there's no, the court denies that or dismisses that argument. There's no specifics. It just simply says obstruction of justice. Prosecutors refusing to respond with discovery, court denies that. Court notes that the district attorney has provided information how Mr. Shadowens can obtain that discovery. In regard to state can't be an injured party, the state does file the cases to enforce public laws and publish violators. The primary goal of the state is to ensure justice for the community, not just a specific individual's loss. So that is, so I deny your
Point of clarity,
dismiss.
please. Objection, point of clarity.
No, sir, I am ruling. It's my opportunity to talk.
You're not hearing me.
You can write down what you.
I did write it down. You're not reading the complete statements.
No,
You're
sir,
not reading the complete, I'd like to read the records for the
No.
record.
No, You are not in control of this courtroom, and you will not be reading from the construction paper that you used to file your motions.
No, I don't, no, you're not going to be reading
Let the
that.
record show the court is
You
denying
can
me a
always
defense.
file that, Mr.
I
Shadowitz.
did, I
I
did.
have-
It's on file.
All right, I have ruled that, that nothing about the state, the fact that all your cases are the state of Colorado versus you does not prevent those cases from proceeding forward. Those cases will continue. In regard to change of venue, there's no reason under Rule 21A of the Colorado Rules of Criminal Procedure to find that you would not be able to obtain a fair or expeditious trial in Teller County. So I deny that request at this time. If you wish to submit some additional information about why you think there should be a change of venue under Rule 21, you should follow the rules there.
I do, it's
The
right here. I'd like to
irrevocable-
read it for the record. please.
Irrevocable trust is an absurd argument. Traveling, not driving, I did rule on the record in this, on that issue before in People v. Zen.